Federal marshals are already on the move. That's not speculation. That's not rumor. That's the confirmed reality inside a federal courthouse that just exploded into chaos after one of the most consequential leaks in modern legal history. Late Thursday night, a 47-minute sealed audio recording known only as the Witness 14 tape surfaced online. And within 6 hours of verifying its authenticity, U.S. District Judge Elellanar Caldwell did something almost no federal judge ever does. She issued emergency arrest warrants for multiple individuals based solely on the contents of a single tape that was never meant to be heard outside a secure room. This isn't a procedural motion. This isn't about legal theory. This is about direct, documented evidence of federal crimes, witness tampering, obstruction of justice, evidence destruction, all captured in real time, and allegedly orchestrated by people in positions of power. Sources inside the courthouse say the atmosphere flipped from tense to volatile within minutes. Phones were confiscated. Attorneys were escorted out. Marshals took positions at every entrance. And behind closed doors, Judge Caldwell watched the tape twice, conferred with her clerks on federal statutes, and then signed the warrants herself. This leak didn't just change the case, it detonated it. The Witness 14 tape, according to early verified transcripts and vocal analysis experts, captures a protected federal witness recounting how they were instructed in detail to destroy documents, alter digital records, coordinate false testimony, and remain silent in exchange for large sums of money. The tape also includes threats against the witness's family, including chilling evidence that photographs of their children's school were sent directly to their phone with a warning. Testimony has consequences. For months, this witness had been sealed from public view, protected under court order. Defense attorneys tried 17 separate times to access the recording. Judge Caldwell denied every attempt, citing the danger to the witness. Now that tape is out, and the danger? It's shifted not toward the witness, but toward those accused of silencing them. This video breaks down everything they didn't want you to hear. What's on that tape? Why Judge Caldwell moved faster than any federal judge in recent memory, and what it means for the people named in those arrest warrants. Because this isn't just a legal turning point, it might be the beginning of a new era in American justice. The Witness 14 tape isn't just incriminating, it's surgical. For nearly 47 uninterrupted minutes, the voice of a protected federal witness walks through what legal experts are calling one of the most damning pieces of evidence ever introduced into an ongoing federal investigation. And it's not just the content. It's the clarity, the specificity, the absolute, inescapable weight of detail. This isn't someone speculating. This is someone who was there and is now telling everything. According to authenticated transcripts circulating among prosecutors and journalists, Witness 14 outlines a deliberate, multi-month operation to obstruct justice. It wasn't sloppy. It wasn't improvised. It was structured. The tape opens with the witness describing how they were personally approached and recruited to clean up certain records, both physical and digital. The first instructions: simple but dangerous. Shred everything related to a specific set of financial transactions. Within days, they were handed administrative access to a digital archive and told exactly what to delete. 3 dates are repeated multiple times: March 14th, April 2nd, and May 19th. On each of those days, the witness says, key actions were taken to eliminate evidence. Files were destroyed. Hard drives were dismantled. Cloud backups were accessed, purged, and reformatted. Then comes the money. The witness states clearly that they were offered upfront compensation for their cooperation, and that at least 4 others received similar payments. The tape includes exact cash amounts: $65,000 in one drop, $120,000 in another. In total, over $340,000 in off-the-books payouts were distributed to individuals tasked with either destroying evidence or staying silent. The witness names names. References drop locations. Even banking institutions are mentioned. But it's not just about financial incentive, it's about fear. Midway through the recording, the tone shifts. The witness explains how they were pressured to stick to a pre-written narrative, a script. If they strayed, there would be consequences. I was told what to say. The voice states flatly. When I asked what would happen if I didn't, I was shown photos of my children's school. The room falls quiet. The interviewer pauses, then asks for clarification. The witness continues calm, measured, but exhausted. The photos came from an unknown number, no words, just the image. A few hours later, a message followed. Testimony has consequences. This is not just obstruction. This is calculated intimidation, and according to federal code, threatening a witness's family, particularly their children, qualifies as aggravated witness tampering, a felony that carries enhanced sentencing and additional charges under U.S. Code paragraph 1512. But what makes this tape unprecedented isn't just the emotion. It's the evidence that backs it up. The witness doesn't generalize. They list badge numbers of people allegedly involved. They describe exact office layouts where meetings took place. They recount direct quotes from conversations and reference emails and call logs that prosecutors have since corroborated. Forensic experts reviewing the tape have confirmed it shows no signs of editing. Metadata embedded in the audio file aligns with the dates provided by the witness. Vocal analysis software has matched the speaker's voice to previous verified recordings. Cross-reference timestamps coincide with other surveillance data already in court records. One legal analyst put it bluntly. This is the closest thing we've ever seen to a live crime confession caught in progress. And it doesn't end there. In the final section of the tape, Witness 14 details a final meeting where high-level participants allegedly discussed how to permanently bury the evidence, including plans to destroy backup storage held by a third-party data management firm. This portion names attorneys, identifies office buildings, and includes dialogue quoted word for word. What we're looking at isn't a rumor. It's a roadmap. A digital blueprint of obstruction, suppression, and fear. No wonder Judge Caldwell didn't wait. Judge Elellanar Caldwell has been on the federal bench for 22 years. She's presided over organized crime, financial fraud, and public corruption. But according to multiple sources inside her courtroom, she's never reacted like this. Not once. Just hours after the Witness 14 tape was leaked and authenticated, she took the bench in an emergency session. No press. No public gallery. Just marshals, court staff, and the attorneys on both sides, many of whom were given less than 4 hours' notice. Some reportedly arrived disheveled, still pulling on jackets. Others looked stunned. And for good reason. Judge Caldwell wasn't there to debate procedure. She wasn't there to investigate the leak. She was there to take action. At exactly 11:47 a.m., she addressed the courtroom. Her tone, one source said, was like steel. What followed were 4 names read aloud. Slowly, deliberately, each attached to a signed federal arrest warrant. And then came the line that reportedly froze the entire room. If any officer of this court had knowledge of these activities and failed to report them, they should consider their own legal exposure very carefully in the coming days. In legal circles, that's not a warning. That's a shot across the bow. Within the hour, 2 defense attorneys requested to withdraw from the case. Judge Caldwell denied both motions, citing ongoing investigations into whether those same attorneys may have been complicit in the obstruction effort. This wasn't a strategic delay. This wasn't the court playing politics. This was a federal judge signaling that the integrity of the justice system itself had been violated, and she wasn't going to wait for the usual gears of process to slowly turn. Former U. Attorney Preet Bharara told MSNBC, "This is exactly what judges are supposed to do. When confronted with overwhelming, time-sensitive evidence of obstruction. Act swiftly. To protect the process itself. Professor Lawrence Tribe, one of the foremost constitutional scholars in the country, echoed the sentiment. The leak may have been illegal, he said, but the conduct it reveals is exponentially more so. The court is obligated to address both, and the greater threat takes priority, and one of Coe's. And the comparisons have already begun. Legal historians are drawing lines back to Watergate, when the Nixon tapes ultimately led to a Supreme Court ruling and the collapse of a presidency. But even then, the legal process moved slowly. Investigations, subpoenas, years of delays. What makes this different is the speed. The sheer decisiveness. Think about Martha Stewart's case. She wasn't convicted for insider trading. She was convicted for obstruction, for lying about it, and even that took months to unfold. With endless deliberation, here, Judge Caldwell reviewed the tape, consulted statutes, and issued arrest warrants within 6 hours. Let that timeline sink in. What's emerging is a new kind of legal moment, one where obstruction is not treated as a side charge to tack on at the end, but as a central crime deserving of immediate intervention. Because obstruction, at its core, is an attack on truth. It's not just about hiding something, it's about sabotaging the very engine of justice. Manipulating what juries hear, what judges see, and what the public believes. And for once, the response was as serious as the crime. This wasn't about headline-grabbing theatrics. This was about restoring control over a system that someone, somewhere, clearly thought they could buy, manipulate, or erase. Instead, they got a federal judge who refused to blink. And that decision, that refusal to delay, may become the most important legacy of this entire case. Not just the content of the tape, not just the arrests, but the precedent. That when the justice system is threatened from within, it doesn't have to move slowly. It can move now. By the time Judge Caldwell finished reading the names in court, marshals were already in motion. These weren't local sheriffs or courthouse deputies. These were federal agents trained, briefed, and executing direct orders from a sitting judge who had declared that criminal activity was happening in real time. And they moved fast. Within hours, 2 of the 4 individuals named in the arrest warrants were taken into custody. One was picked up at their home in the early afternoon. The other was intercepted while attempting to leave their office, reportedly unaware that the tape had even leaked. The third arrest sent shockwaves through legal circles. That individual was apprehended at a private airfield, roughly 90 miles from the nearest international border. On them, over $40,000 in cash, 3 suitcases, and a one-way itinerary out of the country. According to marshals, there was no question about their intent to flee. Sources close to the investigation say they didn't resist, they were simply caught mid-escape. The 4th person named remains at large. Federal officials have confirmed a public advisory has been issued. The belief is that the individual may have already crossed state lines or is receiving assistance avoiding capture. Coordination with other jurisdictions, and possibly international law enforcement, is now underway. Inside the courthouse, the atmosphere has only grown more volatile. Attorneys involved in the case have gone silent. No public statements, no press conferences. One defense team initially released a scathing comment, accusing the judge of abuse of power based on illegally obtained evidence. But the backlash was immediate, not just from the public, but from within the legal community itself. Professor Kathleen Hall Jamieson, an expert in legal communications, summed it up perfectly. When your only argument is that the evidence shouldn't have been leaked, not that it's false, you've already lost the narrative. And the silence has been deafening. None of the named individuals have denied the contents of the tape. No one has challenged the dates, the payments, or the threats. Not a single figure has come forward to say, "That's not my voice," or "That never happened." Instead, Lawyers are scrambling, and not just to defend their clients. At least 2 legal ethics boards, in separate states, have launched preliminary investigations into attorneys mentioned in the tape. If the recordings are accurate, and so far, no one has disputed them, some of these lawyers may have played an active role in coordinating false testimony and obstructing justice. The American Bar Association is reportedly monitoring the situation closely, and Judge Caldwell isn't done. Initial appearance hearings for the arrested individuals are scheduled for the following morning. Prosecutors are expected to argue for detention without bail, citing the explicit flight attempt, the risk of witness intimidation, and the severity of the charges. Meanwhile, witness 14 has been moved to a new secure location. Sources indicate their protection detail has doubled. All communication with anyone outside the protection program has been suspended. One DOJ official, speaking anonymously, said it bluntly. This tape blew up everything. And now the system is racing to catch up. 10 and 7. But this isn't just about who gets arrested or which lawyers lose their licenses. The deeper impact is institutional. For years, critics have argued that high-profile defendants use legal delay tactics, influence, and intimidation to avoid accountability. This case, this leak, just shattered that illusion. It showed what happens when the system moves faster than the cover-up. The consequences are rippling outward. Court clerks are being interviewed. Staff are under scrutiny. Every sealed document is now a potential target for inquiry. If this many people were involved, how many more knew and said nothing? And that's the question no one wants to answer. Because what comes next isn't just about trials. It's about exposure. It's about how deep this goes, and whether the system has the will to chase every thread to the end. What makes this moment historic isn't just the tape. It's what the tape triggered and what that response reveals about the system itself. Because for decades, obstruction of justice has been treated like a secondary offense. A tag-on charge. Something prosecutors toss into an indictment after the main crime is proven. But this case flips that script. For the first time in modern memory, a federal judge isn't treating obstruction as an afterthought. She's treating it like the crime it actually is, a direct assault on the judicial process. And she's acting accordingly. Let's be clear about what the law says. Under it U.S.C. Section 1512. It is a federal felony to intimidate, threaten, corruptly persuade, or attempt to influence a witness. The statute explicitly covers both direct threats and more subtle forms of coercion, including offering bribes, encouraging false testimony, or destroying evidence to prevent testimony. But there's more. Section 1512 also includes enhanced penalties for any action that involves threatening the family members of a witness. This is not a gray area. It's a legal red line. And once that line is crossed, once children are brought into the equation, the offense moves into a higher class of felony. Mandatory sentencing guidelines kick in. Judges lose discretionary leniency. The law stops debating intent and starts punishing outcome. And that's exactly what's playing out now. The Witness 14 tape doesn't just show tampering. It shows targeted psychological pressure, executed with precision. A script forced upon a witness. A veiled threat against their children. Coordinated deletions of digital evidence. Cash moving between hands. All while subpoenas were active and investigators were circling. These aren't allegations. These are admissions with receipts, and the response from Judge Caldwell could now become a model for how federal courts respond to obstruction going forward. Because one of the enduring criticisms of the U.S. legal system is that it moves too slowly, especially when powerful individuals are involved, that cases die in committee, that delays pile up, that lawyers exploit every inch of procedural gray area until public attention fades and accountability disappears. This case changes that narrative. It shows that when the evidence is overwhelming, when the risk to justice is immediate, courts can act in real time. Arrests don't need to wait for grand juries. Warrants don't need to wait for press conferences. If someone is actively undermining the system can strike back. And it's not just about speed. It's about deterrence. Because every defendant, every attorney, every fixer who thinks about tampering with a witness after this, they'll think twice. Not because of the law on paper, but because of what they saw happen here. Legal experts are calling this a judicial flashpoint. A possible precedent setter for emergency intervention in obstruction cases. A sign that the rules of engagement are changing and that tampering, once considered low risk, now carries high consequence. And make no mistake, the ripple effects are just beginning. Prosecutors in other jurisdictions are already reviewing sealed witness statements in their own cases, asking one key question. Is this happening here too? Internal policies around evidence security are being rewritten. Witness protection protocols are being re-evaluated. Ethics boards are tightening their review processes, because the implications of this case aren't just legal, they're cultural. It challenges a long-held assumption that powerful people can manipulate the legal system if they just move slowly enough, throw enough lawyers at the wall, and avoid leaving a paper trail. Witness 14 broke that pattern. They recorded everything. And now the system is relearning how to defend itself. What Judge Caldwell has done, whether intentionally or out of sheer necessity, is shift the burden. No longer does the court wait passively while cases are sabotaged behind the scenes. Now, obstruction itself is the emergency. And emergency response is no longer optional. This is how the rule of law survives. Not by patience, but by courage, by action. This case was never really about a single witness or a single recording. It was about how power behaves when it thinks no one is listening, and what happens when someone finally records everything. 47 minutes of audio did what years of sealed filings, procedural delays, and legal maneuvering could not. It forced the system to look at itself. And for once, the system didn't look away. What followed wasn't cautious. It wasn't slow. A federal judge watched the evidence, weighed the risk, and acted. Arrest warrants were signed. Marshals were deployed, and obstruction of justice was treated not as a technical add-on, but as the emergency it truly is. I'll be honest, I didn't expect this. Too many times, we've seen cases like this fade into silence. Witnesses get worn down. Evidence disappears. Attention drifts. Power waits it out. This time, something broke that pattern. For once, the truth reached the courtroom before the narrative could be rewritten. And that alone makes this moment different from almost everything we've seen before. Now the question isn't whether this case matters. It's whether this response becomes an exception or a standard. Whether this was a reaction to extraordinary circumstances or the beginning of a shift in how the justice system handles people who try to corrupt it from the inside. And that depends on what happens next. It depends on how closely this is watched. Because systems don't change quietly, they change when people refuse to stop paying attention. If you think this story matters, share it. Talk about it. Leave a comment with what you think comes next. Not because it helps a channel, but because sustained attention is the one thing powerful people can't outrun. And if this case continues to unfold, the hearings, the filings, the consequences, I'll be here, following every step until we see exactly how far this goes. One last thing needs to be clear. Everything discussed here is based on publicly available information, media reporting, and expert analysis at the time of recording. This content is presented for informational and educational purposes only. It reflects commentary and opinion, not legal conclusions. No individual mentioned has been found guilty of any crime unless and until proven so in a court of law. This is not legal advice, and viewers should rely on official court proceedings and verified sources for authoritative updates. But with that said, one fact is already undeniable. One voice came forward. One tape surfaced. And the system moved. Whether it keeps moving, that part hasn't been decided yet.